Okay, welcome everybody. We might get started. We are pretty close to being on time. So welcome to our second of the year, I think. Third of the year. My God, it's already going through.
Wow.
There we go. So I'm Kirsty Smith. I am a lecturer here, and I'd like to introduce Kiri Rowan. Kiri has practiced extensively in wills, estates and elder law in the Toowoomba and Darling Downs region across the past 13 years. She holds Bachelor of Laws from QT and in 2022 completed her Masters in Applied Law, majoring in wills and estates. Kiri is one of only 3 registered trusts and estates practitioners in the Darling Downs, and she is recognised by the International Society of Trust and Estate Practitioners. She was also the first lawyer in Toowoomba to be accredited as a collaborative practitioner in wills and estates. So hopefully that will continue to grow. That actually can keep happening.
That's the aim.
She's also a past committee member on the Down South West Queensland Law Association and is the current Toowoomba and Darling Downs delegate for the Wills and Estates Subcommittee on the Queensland Association of Collaborative Practitioners. So today, Kiri will be presenting really an introduction on the collaborative practice model in wills and estates in Australia, and particularly as an alternative to litigation and that traditional lawyer-led alternative dispute resolution type method. So welcome, Kiri.
Perfect. Thank you, Kirsty. Hey, welcome everyone, and thank you for braving the rain and the weather and the wind to come here today. I really do appreciate it. So I'm very excited to talk to everyone today about collaborative practice in wills and estates. So it's a resolution-focused approach to conflict over inheritance. So what I'm going to be talking to you about today is something that is completely different to traditional litigious parts and also completely different to traditional lawyer-led alternative dispute resolution. So there we go. Okay, so what I'm going to be covering today is why we're going to do things differently. So the changing climate of dispute resolution here in the wills and estates context. I'm going to be covering what is collaborative practice and how is it going to be actually different to traditional lawyer-led negotiation. I'll cover where it began and how it's now being applied to prevent disputes and how we're using it in wills and estates both in the pre-death context in estate planning and in the post-death context in contested estates. I'm going to be going through the roles of the clients and of each member of the interdisciplinary team. There's lots of people who are involved in this collaborative law practice. I'm also going to be talking about the value of the neutrals in the practice. So that's your financial neutrals and also your communications coach, which is different to any other type of alternative dispute resolution. We're going to cover how is it actually different to mediation, and lastly at the end, how everyone can get involved. So why do we want to do things differently in wills and estates? So we are about to witness in the next 2 decades the biggest transfer of generational wealth that we have ever seen. All of the baby boomers are going to be passing their wealth down to the next generation. And they want to do that in a way that we're going to minimise the fights, we're going to maintain the family relationships. We also have quite a unique situation nowadays of entitlement of beneficiaries. People are often in a lot more debt than they were in the past, and unfortunately a lot of people are now relying on an inheritance to wipe out that debt and to make ends meet. Another reason why we want to look at alternatives to litigation and alternative dispute resolution is the cost of litigation. Now, when I say the cost, I don't just mean the financial cost. Nobody comes out at the end of a litigation process with that family intact. It wrecks relationships. And what we're talking about here is that where collaborative law started was in the family law context, and that relationship was already deteriorating. Here we're not just talking about 2 people who are separating. When we're talking in wills and estates, we're talking about an entire family, and we're talking about the next generation as well, and that relationship is potentially on the line there. It also then, nowadays, has an effect on family businesses. Small businesses, small family-run businesses are the backbone of our commercial enterprises here in Australia. And if you get a dispute within the family with someone dies, that family business can crumble. So bringing collaborative law into the practice is a way to maintain that family relationship there in the business. It's also the significant financial costs of the litigation process. There's, we're under no misconception as to how much it costs to take a matter there to court. And whilst a collaborative law practice is by no means cheap, it is never going to get up to the cost of what litigation can process. And at the end of the day here, when people make a will and they give an inheritance, we want it to go to the beneficiaries. No lawyer wants it to go in their back pocket, and no lawyer wants to make money out of these disputing families. They want for it to go to the beneficiaries. It's also the emotional toll of litigation. And that's something that we explain to clients right at the first point when they're looking to contest an estate, is that this is not a quick, easy process. You're in for a protracted battle. And it's not just the financial impact it's going to have, it is that emotional stress. It's all you're going to think about for those 3 years. It's always going to be hovering there in the back of your mind. And people often downplay just how much that impacts their lives. It impacts their own other relationships. It impacts their work. It impacts their life. I've heard clients explain that they just write off 3 years of their life when going through a deceased estate litigation process. So we need to do things better. So how do lawyers see things in the traditional lawyer-led negotiations and in traditional litigation parts when it comes to deceased estates and contested estates? So typically what happens is that a client comes to us and they tell us that they have these issues here that the client has identified. Now, our job as lawyers is to alert them to issues that they might not have already even considered. So that's when they're the realm there of the issues, it gets a bit bigger there. So we've got the issues that the client brought to us that were important to them, but now we're going to make that circle a lot bigger and we're going to say, oh, but have you thought of this? Have you thought of this? Have you thought of this? Next thing, the client's mind is just expanding and exploding with all these additional things you've just thrown at them. We then tell them, though, that we need to reality test your situation. And what we then do is say, well, look, we need to give ourselves a best case scenario buffer as to, at the end of the day, what you would be happy with. And when we deal with traditional litigation and traditional negotiation and mediation, we end up getting to the end of the day when all the nasty affidavits have gone backwards and forwards and a lot of damage has already been done. We get to a 10 hours in the mediation when people are exhausted and we tell them, you know how we originally expanded it out to the issues you wanted and all the issues we brought to your attention? We need to press that right back down and we need to come to an agreement on these core issues, and we need to come to that agreement today, and we need to do this quickly, otherwise we're off to court and you're facing a lot of money down the track there and even more stress. So we expand clients out just to bring them right back down. And what do we also notice so last year when I did the collaborative practice training, the trainer, who I'll speak to a bit more about later in this presentation, she really honed in on us that everything we know as a lawyer and how we see and identify all these issues, if you think of contested estates, depending on what jurisdiction you're in, only about 15 to 5% of those cases actually make it to court. And usually those are the cases where it's the most dysfunctional families and it's the most complex issues. Now, we as lawyers, we then have clients who come to us with their contested estate matters, and we have our blinkers on here, and the clients are telling us, look, these are all these issues that are important to us. But our job there as lawyers, we say, well, look, the case law says these things are important, and the case law says this is what we need to focus on. So what we have actually trained ourselves to do as lawyers is that we are taking the worst case scenarios, the 15 to 5% of cases who make it to court, and those things that judges held were important in those cases, we're applying that to the 85 to 95% of other matters that would not have even made it to court. And we are inflaming and complicating that situation. Those issues that are actually, even though a court at the end of the day held these issues were important, when we're in the realms of before we get to court and we're trying to negotiate it out for these families, the other issues there become even more important there to those clients. And that's what we need then to focus on. So when we're talking about collaborative practice as an alternative to litigation and lawyer-led negotiation, we need to think of what is driving the disputes and what is driving these clients. So we find that the factors that are driving the disputes in the contested estates, first up, it's the justice and it's the legal entitlement. You know, I'm the spouse of so many years. I'm the sole child. I've been in their life more than anyone else. It's that legal entitlement to inheritance. We're also finding nowadays it's a lot of the financial strain and the need. Remember how I spoke to you about people up to their eyeballs in debt and they're sort of waiting for the inheritance to solve those issues? When that inheritance then doesn't come through, they're in a pickle there. They were relying on that inheritance to pay off that huge mortgage with the huge interest rates. And so now that's motivating them to make that claim. We also have issues potentially of undue influence and power there. We always get questions thrown out at us that, you know, when dad made this will and he's given more to this child than the other children there, was that dad's own free will? Was that child there in his ear? So those are the suspicions there that can drive a claim. There's also the past injustices and revenge. I've met with so many clients who, even if they sort of what they are getting in the estate is adequate, they don't feel it's fair that throughout their life, dad paid for the schooling and the housing and everything of one other child, and they got no help at all during their lifetime. So it's my turn now to get my share. And they sort of take it as, correcting those past wrongs. There's also a lot of anger and grief that is motivating these claims, and that presents itself in different ways there and can push people to make these family provision applications. We then have sort of the personal factors that are driving that particular client. You know, we have as to why they're involved here in that process. It is maybe their values, like who do they value in their own culture as to who has received this inheritance. It's their fears as to, well, look, am I going to be okay financially at the end of the day unless I get more of this inheritance? You know, should I actually try and get a greater share of this pie now? It's also a sense sometimes of doing the right thing, you know, that, oh, mum wanted this to happen, or this is what dad wanted to happen. So I feel a real sense of moral right to make sure that that is done. We also have the relationships here that are factors there driving the clients through the process. You know, they feel that their relationship maybe wasn't as fractured as the will maker had made out, and they sort of have it on them to prove that they were a good son and they were a good daughter, and so they should be getting more of the estate there. We also sometimes actually have sort of a hope there that's driving this process. I remember very interestingly one person sort of making a family provision application because they wanted to sort of make sure that they were still involved with the grandchildren. It was a blended family situation and the spouse wanted to be involved with sort of the step grandchildren, and that was driving them to actually make a deceased estate claim to ensure they were still going to be involved in the lives there. So it's all these different things that can be driving our clients. So what actually is collaborative practice? So it is an early stage, client-driven resolution process without the threat of litigation. So remember how I said in mediation, we're sort of waiting for the 9 months, everyone's put in their material, all the affidavits have been filed, and then we're sitting in the mediation room now. And that's near the end of the process. This is very early stage. We're meeting in the first few months. And it's not just one meeting, it is a series of meetings throughout the process. So we're capturing it early, we're capturing it before all that inflammatory material is going backwards and forwards that's lawyer driven. But what really changes this process, there is no threat of litigation. So if you stay within the traditional realm there of contested estates, and if people are doing the lawyer-led negotiation or the mediation, they always have their eye on the courtroom door. They always have that in the back of their mind that we could end up in court and that's there at the end of the day, and that is just there at the back of their mind. When you say we are going to step aside from the traditional methods and we're going to take a collaborative law approach, you actually sign a contract that you will not take this matter to court and you will not be facing litigation. So all parties there involved in the process cannot be taking this matter to court. We are signing a contract called a participation agreement where we agree that court is not going to be an option for us. We need to resolve this dispute here within the collaborative law process. We haven't got that option there. We need to give it our all here. We're also working within a multidisciplinary professional team. So in your traditional mediation, we have your lawyers involved. Here, when we have a collaborative law approach, we have the clients. Each client is also represented by a lawyer. We then have two neutrals. We have a financial neutral whose role is to provide financial information and scoping and modelling to all parties. And we also have a communications coach whose role is to facilitate the session, encourage the creation of options and to bring up the issues there. So we have a multidisciplinary team here assisting these clients, and we're taking a very holistic approach. Like I said, it's also a series of meetings. We're no longer getting to the stage where, it's 8 p.m. at night and everyone's exhausted and we need to come up with a solution now because this is now the end of the mediation. The meetings are going for no more than 2 to 3 hours, and we're having at least 3 meetings, sometimes more. Because I know way too many lawyers. We've had clients who come to an agreement at 8 p.m. at night. We come into the office the next morning, there's a missed call and there's a voicemail that the clients feel they made a terrible mistake. They did it all under pressure. So we're taking away that pressure there. So what it is not. So collaborative law is not peaceful or easy. And where it often gets mixed up as well, and indeed, unknowingly what I thought it may have been before I did the training. And this is why I put this picture here there of people all around a circle, because people tend to get in their head that we're all just sitting around holding hands, singing Kumbaya and wishing for the best outcome here. So it is not that. It is not peaceful and it's not easy. If anything, it is often very emotionally intense and emotionally difficult because we are getting people it is client driven, not lawyer driven. So you think of a mediation where the lawyers are doing all the talking and the client's told to shut up and just stay to the side there. Particularly in our first meeting, the lawyers hardly talk. The clients are doing all of the talking and they are leading this process here. Right. So it is very confronting and it can be very intense for them. They're not just a bystander in their own process. They are proactively coming to their own resolution. It's also not working collegiately within the traditional framework. Again, mistakenly, I had thought that when I was going to be trained as a collaborative practitioner, I was going to be taught to, how to pick up the phone and soften the blow before we send a nasty email, or how to work better and more respectively with my colleagues to come up with a solution there for the clients. I thought it was going to be teaching me to work better within the traditional framework rather than being a completely different framework entirely. It's also not a miracle cure that's going to work in all matters. When you become trained as a collaborative practitioner, 50% of your training is dedicated to deciding who's going to be an appropriate client and what matters are going to be appropriate. So 50% of our training is dedicated to that intake process, to even seeing if this is going to be appropriate for these clients. It's not going to work for everyone. So, those families who have no interest, we've got Australian children, no interest in maintaining the relationship at all, unlikely this process is going to work for them. However, if let's say we have a farming family who have worked together very well their whole lives, but we now, upon a parent's death, have just had this dispute come to the forefront and we're just now in conflict about this, very well we can work towards a common goal there because we have that background of them wanting to maintain that relationship. It's also not mediation. It works very differently to mediation. So the framework here for collaborative practice. Now, I feel the key part of collaborative practice is the participation agreement. So that is the contract that the client sign and the lawyers sign, but we're not going to take this matter to court. So the participation agreement, now our local collaborative law associations have come up with a model participation agreement that collaborative practitioners have access to. And this has been developed with the Australian Law Council. It's been developed with guidance from QLS and guidance from Lexon as well, which sets out the process that must be followed, and this must be signed by everyone before. So once we've figured out that we've interviewed each client and yes, you are all suitable, then everyone needs to sign the participation agreement, the clients, the lawyers, the financial intermediaries, the coach, before anything further happens. The reason for that is that we have some very key clauses in here that if anyone at any part during the process threatens that they're going to take this matter to court, the entire process ends and the whole team has to exit. So if I'm representing clients in the collaborative law process and my client in the middle of the meeting gets frustrated and threatens to go to court and storms out of the meeting, that collaborative law process is at an end. Me and my firm cannot then represent that client again if they choose to go to litigation. They have to start the process completely again, right back at the beginning with new lawyers and start the litigation process. And not just my client, every single member of that collaborative process, all the other clients have to scrap their own legal counsel and start back at the beginning again. And anything that had already been disclosed in the collaborative law process, because another key part of it is we are talking full disclosure here. Everything is upfront. So those things that in traditional alternative dispute resolution you may have kept secret. So let's say a spouse who is arguing for a greater share, but they've actually already repartnered and they're planning on moving in with their partner after this settles. They need to be disclosing that in this environment here, in this collaborative law practice. So that's something that they otherwise would have kept up their sleeve and not disclosed. It would have tactically, it wouldn't have offered that information. Here in collaborative law practice, all your cards are out there. We're not hiding things. We are giving an honest account of everyone's situation and financial circumstances so that we can come up for a resolution there for everyone. And if I, as a lawyer, if I get wind that my client is not disclosing things, I have to withdraw from the matter and I cannot be involved anymore. And the collaborative matter has to cease. So that's how serious it is. So clients can have spent a lot of money getting it to that stage for then it not to be able to continue. So that's why at the beginning we have to be so clear with clients, look, you are agreeing that you are not going to be going to court with this matter. You are going to be sorting it here within the realms of collaborative law practice. Now, the only exception for that in the wills and estates context is that we are allowed to maintain our clients' rights in terms of the 9-month time period. So we are allowed to lodge the claim to preserve rights. That is the only carve-out in the collaborative practice participation agreement that we are allowed to do that is along that court process. Now, in addition to the participation agreement, every single member of the interdisciplinary team will have a separate costs agreement with the client. So the lawyer is going to have one with their own client. The financial neutral is going to have one with each client, and the coach is going to have one with each client as well. Now, as I said, there can often be multiple lawyers involved. So when you think, when we have a traditionally collaborative law started in the family law context where we've got two people separating, well, in your estates, we can have multiple parties here. We can have 4 children. We can have a spouse and 3 children. We can have absolutely multiple parties here. It is also very much an interest-based negotiation model, which I know all good alternative dispute resolution courses focus on, as opposed to traditional positional negotiation. This is very much interest-based at its core. So, where did collaborative law begin and where is it now being applied? So collaborative law started in the USA in 1990, and it was all started by a man by the name of Stuart Webb. Now, he was a practitioner in the USA, and he actually wrote a letter to a judge in the USA, and this is an extract from part of that letter, where he actually said that sometimes when I'm assisting clients in negotiation, often it's just by fluke, there is actually a positive, proactive environment where, we've got this energy happening where the clients are throwing out alternatives here, and those alternatives are welcomed and admitted and permitted in that context. And then at the end of the day, everyone's feeling a lot more satisfied. And these matters, they don't pop up very often, but sometimes the dynamics in the room create this environment. And it's just this absolutely incredible resolution process here that these families here are driving. So what Stuart Webb said in his letter to the judge is that if this can happen sometimes by fluke in the mediation process, why don't we actually create a model where we create this settlement environment deliberately? So it's not just by fluke, we purposely create the environment for these resolutions to come about. So from there, from the US, collaborative practice has now been happening here in Australia. So in 2005, collaborative practice started here in the family law context. So there's now many practitioners in the world and here in Australia who are family law practitioners who are collaboratively trained, and it has been used very successfully in that family law context. Following on from that, here in Australia, we now have associations. We have the Australian Association of Collaborative Practitioners, and here in Queensland, we have the Queensland Association of Collaborative Practitioners, separate bodies set up to support the current collaborative practitioners. Now, the collaborative practitioners started with the family lawyers in 2005. It wasn't until about 2015 that we started thinking, well, why don't we move this into wills and estates? Over in the US, they were already practicing in wills and estates with collaborative law with great success. It is a thriving area in the US. So our mission has been since 2015, we now have it established very successfully here in Australia in the family law context. We need to replicate that and bring it into the wills and estates context. But it's not without its challenges because it's different. Wills and estates is different to family law. So if you think with family law, like I said, you've got the two adults there. Whereas with estate law, we can have multiple parties. And not only have we got multiple people, but sometimes they're acting in dual capacities. So we can have an executor and who's also a beneficiary. We also can come into issues with we have children, minor children who needed to be represented, beneficiaries who are disabled. All of that comes into the mix. And another thing that makes it more difficult is that when we're doing the initial screening of clients to see if they are suitable for the collaborative law practice, in family law, we just need the two clients to be suitable, the two people who are separating. When we are doing it in estates law, we need every single client to be suitable. So if we have a six-party matter and 5 people are suitable, but one's not, the entire matter is deemed not suitable for collaborative practice. So it's harder to get suitable matters. In family law, there's always those 2 lawyers and there's always the financial neutral, and sometimes there's the child psychologist or the social worker. In the estates law context, we also, in addition to the financial neutral, if we're in the estate planning context, we'll always have the will maker's lawyer, but often, and particularly if there's a family business, we'll have their accountant in the room as well. And then in family law, depending on which jurisdiction you're in within Australia, sometimes they do have a communications coach and sometimes they don't have a communications coach. It's been deemed that in the estates realm, that a coach is absolutely essential. And sometimes when we have multiple clients and multiple parties, sometimes we need 2 coaches. Then when we jump into the wills and estates practice, so family law, we're just all under the one umbrella there. When we go wills and estates, we then separate it out into 2 types of collaborative practice. So we have the pre-death context. So that's family inclusive estate planning. So that's when we are involving the potential beneficiaries in the process as sort of a preventative measure. And it was funny, when I was being trained last year, the lady training us said that there will be moments throughout this course where the penny will just drop and you go, oh my gosh. And as I was sitting in that training, the solicitor next to me, who was a very well-respected litigation lawyer from Western Australia, he was looking at a case example there. They did a mock presentation of this collaborative law practice being used for a blended family in the estate planning context. And he actually said, if this happened over in Western Australia, 70% of the files I've got on my desk at the moment would not have eventuated if this had been done at the estate planning phase. Because he said at the moment, we're having people who are doing their estate planning without it being family inclusive estate planning are making major life decisions based on assumptions. So he said in some of my cases, my will maker, when we're dealing with a farming family, they're making major asset decisions on the assumption that that son they're giving the farm to actually wants to stay on the farm and to farm it, which might not be the case. Sometimes when we're dealing with blended families, the children assume that their own biological parent is the source of all the wealth in the relationship, Whereas sometimes it actually comes to the fact that the biological parent was quite destitute and too embarrassed to say it was the step parent who was actually holding up the relationship and responsible for all the assets. And if this had been disclosed at the estate planning stage, maybe those claims in front of the table right then wouldn't have come to fruition. We then, in addition to the family inclusive estate planning phase, we then have the estate dispute resolution phase. So that's the post-death context. So that's when the person has already passed away. Unfortunately, we didn't do the collaborative practice then, so now we actually do have potentially a dispute on our hands here. But instead of going for the traditional lawyer-led negotiation methods and litigation, we're going to try and sort this out, this actual dispute out now, using the collaborative process. So, what actually is the collaborative law process? What actually is a collaborative matter and how is it run? Now, excuse my slide here not being the greatest, but this slide here sets out the 5 stages of a collaborative law matter. So remember I said it's not just this mediation all in the one day, it is a completely staged approach. So the entire first stage takes the most effort. So that's the one where we are actually sussing out whether these clients and this matter is going to be suitable for collaborative practice. So it's our first client interview, and we're doing that intake to assess for the suitability there. If it then does actually come up, my gosh, we potentially have a matter here, it's then assessing the suitability of every other single participant there in that process. We're then preparing for the first collaborative meeting. We need to get those participation agreements signed. We need to make sure that all the individual cost agreements have been signed with the financial intermediary and the communications coach. Then we have our first meeting. So the professionals, the lawyers for each client, the communications coach and the financial neutral all have a meeting before the first meeting with the clients. So we have a professional meeting beforehand to try and identify some issues, get some more background information and see how that first meeting with the client is going to go. Then at the end of that first stage is when we actually have our first client meeting. And unlike a mediation where we're talking about the issues, the options, and we're negotiating and we're documenting the resolution all in the one day, the first meeting is purely about let's identify the issues. And this first meeting is very confronting as a lawyer because as a lawyer, you're used to running the whole show and doing all of the talking, whereas the first meeting, you're really stepping back and letting the clients talk about, with the guidance of the communications coach, which is why they're so crucial, what issues are important for them and what they want to bring to the table. The second stage there is the information gathering stage. So if we've come up that we need real estate valuations done, you know, if an issue regarding a property was brought up, that's where we get the real estate valuations. Do we need other supporting documents? Do we need other financial advice based on those issues that were brought up? Stage 3, we have another meeting there. And that's where we go through the options. So this is where the lawyers get excited. This is where we really get to bring quite a lot of value to the table. So the clients have brought up they had these issues. It's now the lawyer's turn in this meeting to assist with generating some options. Then the final meeting there, that's when we narrow down the options and we do the interest-based negotiations to try and come to a resolution here for these families. The final stage there is the agreement. So that's the written agreement there. And if need be, let's say for stamp duty reasons, we need to get actual stamped orders. That's where that goes ahead as well. Now, we don't have to have just the 3 meetings. We can have multiple meetings if stages require multiple meetings. There's no pressure there on those clients to get it all sorted in the one. So then we have our interdisciplinary, so that's the process. We then have our interdisciplinary team. So as you can see here, we've got, so for client A, we've got client A's lawyer, client B, we've got client B's lawyer, we have the financial neutral, and we have our communications coach. So this is your entire team there. And for every other client that we have, like I said, if we've got a spouse and 3 children as part of the estate dispute, we'd have 4 clients and 4 lawyers there at that meeting. So the client, it's very important to remember that not every client is going to be suited to this process. So clients who want to partake in this collaborative law process, they really need to shift their focus from past blame to future needs. If you have clients who are just too fixated on what their siblings did in the past and how terrible mum was and all the injustices, you're not going to get them contributing into this collaborative law environment. We need to be finding clients who are acknowledging that, look, we have a dispute at the moment, but at the end of the day, we actually still want to be able to sit around for Christmas dinner together in a year's time. And, or I still want to be able to go to my grandchildren's cross country without my son refusing for me to be there. We need to have clients who have preserving that relationship as a main priority for them. Right. Just what we've noticed, some cases because that is what is so important for these clients, we're really finding that there's certain types of families where this collaborative law process can just be amazing. I'm talking your long-term blended families. So I'm talking blended families where the spouse has been very involved and is a long-term spouse and has often been very involved in the children's upbringing. And we just now have this issue here where biological parent has passed away and there's just that bit of uncertainty between the spouse and the kids, what is going to happen now? We're not the traditional nuclear family, but there was always that relationship there in place. We find it works very well with farming families now. We have that overriding, wanting to preserve the family farm, wanting to maintain that legacy. We're finding it lends very well into families who are operating a family business together. We've always worked well in business together. We want to continue working well in business together. It's just, mum was the glue holding this business together and mum's passed away now and now we're just fighting over it. So we're finding those types of clients, this process can really aid them. So what we're finding is that those clients who this is a suitable process for, it is miraculous. It does wonderful things and it is a revolutionary process for them, and it's absolutely not for every client. You get to know that after a while. Some clients come in your door and they're angry and they're all about their rights and they don't care if they ever see, mum's spouse ever again. They're not going to be suitable for this process. We then have the role there of the neutrals. So your communications coach, so they are independent. No, they don't act for a particular party, they act for everyone in that entire process there. And so their role there is to identify the goals and the values and the issues there that the clients are presenting. And they're also there to help in sort of seeing the parties, see things from other people's perspectives. They're a safe neutral because it's not like I'm client A's lawyer trying to get client B to see my client's perspective. They are independent, trying to get everyone to see everyone else's perspective. So these coaches are very essential there in that process. We then have the financial neutrals. So their job might include determining what the assets and liabilities are of the estate, doing budgets and cash flows for each party, as well as debt structuring. Where I've seen them be so valuable, it was actually amazing. As part of the training, we had Elston Partners down in Brisbane. They have financial planners there who are collaboratively trained to be financial neutrals. And they were able to show that, look, if you can actually bring to that second meeting there with that options generation stage as to, well, look, this is actually your client A, these are your needs going forward. This is how much money you will require for your lifetime. So it's not just, I want this, it's what you will actually need. And they can even do some incredibly clever modelling here as to, if you get this now, how much do you need now to actually sustain yourself? And it was really amazing. One of the examples they put up on the screen as part of the training was giving the example there of, the biological parent passes, spouse has a right to reside in $1 million house that the kids will get at the end of the day. However, with some financial modelling showing that the spouse actually didn't want to live in that house, they wanted to live in a different neighbourhood. And if the child actually got $300,000 now instead of $1 million or whatever that turns into, when that spouse passed away, the child was actually in a better financial position at the end of the day, getting a smaller amount now rather than waiting for a larger amount at the end of the day. So they're able to show all this different modelling here, which was really in that particular example they gave, was able to show each client, look, what do I actually need? What do I need? And what amount now is going to make that come to fruition. We then have the lawyers here in this process. Now, it is, you really need to do a mind shift when you're a lawyer in a collaborative law matter because we are so used to taking the lead and we're used to running the show. So here, the role of your lawyers is that you are an advocate for your client, you're a wise advocate, and you're also their ally there. You're sitting there beside them and you're promoting that positive relationship there with the other professionals. We need to be able to learn how to give up control over the process and to let our clients guide that process, which is very different from your traditional mediation. Which leads us on to our next slide there. So if we think then about if we put litigation to the side and we think just about mediation versus collaborative practice, so what's the difference there and why is this process important for the client? So if you think of the client in a traditional mediation process, they have that fear that we could end up in court if I don't sort this out. If we don't sort this out today, I'm going down that court path there. Whereas in the collaborative practice, they know, well, actually, we've signed a contract that we're not going to go to court and we're committed to resolve this practice now. In your mediation, your clients will talk with their own lawyers, but in the actual mediation, they don't often talk that much. It is lawyer-led. Whereas in your collaborative law process, particularly that first meeting, it's very much client-led and the client is empowered and the client is engaged and the client is saying, these are the issues important to me and what we want to talk about and what we want to resolve, rather than the lawyers saying, well, 5 to 15% of all contested estate matters say these things are important, so this is what we're going to be focusing on. It's different then for the professionals as well. In the mediation, the lawyers are taking a very active role, whereas in the collaboration process, we are still absolutely essential, but we are the advocate for our client and the ally, and we are letting them guide that process with us stepping behind them. And we're really at that options generation. That's when we're coming up with the legal options for them, but it's based on the issues that they've raised for us. And where it sort of changes for just the changing face of the practice there. So clients are seeking ways to minimise their conflict there. Clients did not want the traditional litigation path, so that's why we came up with the alternative dispute resolution as another option for those clients, a low conflict option. We're finding though that in the mediations, it's still not perfect there. We still have clients who are exhausted at the end of mediation and wishing they hadn't agreed to things. We're still having the affidavits, which are very inflammatory, going backwards and forwards. And even though we didn't make it to court, the damage is already done and we're just not going to maintain this relationship with the person on the other side of the table. And clients don't want that nowadays. Okay, some clients may want the fight and some lawyers may want the fight, but most of us do not. Clients come to us with an issue, but they come to us because they want a resolution. And so this is a way that we can give them a resolution in a low conflict way. And this is a way that we can enable them to maintain relationships with other parties in the matter, which otherwise would have been irrevocably damaged if we went through other traditional methods. Ultimately, though, when we talk about collaborative law and when we talk about bringing it into the wills and estates context, we need to always do a bit of a reality check here with our situation. Collaborative law is not just, it sounds wonderful, but it's not just this magical wand we're going to be able to wave over and it's going to be suitable for all clients and all matters. It is going to be particular clients and particular matters that are going to suit this process. It is not a one-size-fits-all situation. We also, however, have the benefit of learning from the family lawyers. So the family lawyers are a decade in front of us. They started this in 2005 here in Australia. We only started in 2015. So we get to learn from them. We've been able to base our participation agreement on their participation agreement. We've learnt from them as to how the communications coach is so essential. We've learned to them how the financial neutral can be utilised. So we get to keep learning from them, but they are still 10 years ahead of us. There are a lot more collaboratively trained family lawyers than there are collaboratively trained wills and estates lawyers. And that's another issue as well, because when clients have an estate dispute and they go and get their initial legal representation, if they go to a lawyer who is not a collaboratively trained lawyer, collaborative law is not an option. So even if that particular matter was perfect for collaborative law, if one party in the proceedings has teamed up with a lawyer who is not a collaborative lawyer, they've gone and jumped the gun and gotten their own representation and the lawyer's not collaboratively trained, the matter is now unsuitable for collaborative law. So as far as collaborative law is sort of moving forward within the wills and estates realm, we really need to come at it from, it's a chicken and egg situation. We need to make sure there's enough education and awareness out there for clients so that they know that collaborative law even is an option, so they don't go and, unknowingly pair with a wills and estates solicitor who is not collaboratively trained. They can actually seek out a collaboratively trained wills and estates lawyer, or they can bring it up with their lawyer. And if that lawyer is not collaboratively trained, they can refer them to a lawyer who is. So then the other side of the coin is actually having enough lawyers around here in Australia who are collaboratively trained in wills and estates, so that there's more likelihood that when a client goes to a lawyer, that lawyer they're meeting across the table with is going to be, one, aware of this as an option, and two, accredited to practice in it. So how can we learn more? I've given you the intro here. So how can we learn more about collaborative law? So pretty much everything I've been talking to you about today, I owe to an incredible woman by the name of Zinta Harris. So Zinta is the lawyer who actually went over to the US. She saw that our family lawyers were doing this here in Australia, and she heard they had brought it into the wills and estates realm in the US, and she went over there and she was trained how to practice collaboratively in wills and estates. Since then, she has been back and she has been a presenter at international collaborative law context. So she is the sole person who has brought collaborative law to Australia, and she is now training collaborative lawyers within Australia. So she has released a book, Rest in Peace, which is actually available for clients who can read about the collaborative law process, and she undertakes training on a yearly basis, not only for lawyers learning to be trained in this area, but for current trained lawyers looking to do the advanced training there. So I absolutely have to give her credit for everything I'm talking to you about now. Okay, that is, in a quick hour, everything I took a while to be trained in. I guess I'll open the floor now if there were any questions. Yes?
Thank you for that. Very interesting. I was just interested about the point of settlement where the lawyer is less like the lawyer.
Mm-hmm.
They're obviously communicating a fair bit. And you didn't necessarily call it a conciliation, but they're being less than their normal lawyerly settlement.
Mm-hmm.
Could you describe that settlement, the point of settlement there?
Yeah, so that's that stage 4 in the process there. So when we're getting to that point of settlement, we've already had at least 2 meetings. So we've had, and these are group meetings with everyone there at the meeting there. So we've had that meeting to talk about the issues. We've then had the meeting there to generate the options. Then we have the settlement the settlement meeting, you would call it, where we're narrowing down those options. We're doing the interest-based negotiation. And we actually then are coming to that agreement. So then following, and that can go over the space of 2 meetings. Again, they're never more than 2 to 3 hours. So we may need to space it over 2 meetings. So then from there, the actual written settlement, typically that would be done by the lawyer there for the estate. That would typically be done by them and then circulated around to the others there. So that's how that sort of documentation of the settlement would happen. But it's not similar to sort of your mediation where we're having that meeting in the one and then at the end of the day, we're signing everything off there. It's often we're coming to sort of an agreement there at that 4th stage in that meeting, but then in the 5th stage is when we're actually documenting it. So again, there's not that pressure there. Yeah.
And another one with Reed.
Yes.
Yeah, I've got a series of questions that relate to potential disputation. The collaborative practice over the estate plan, imagine the outcome of that is a will.
Yes.
So the testator is involved in that. When then the testator dies, are you ever aware of a situation where the beneficiaries mentioned that part of the participation agreement, whether they then change their mind, and so whether you need to go into stage 2,
Mm-hmm.
and yet
Yes.
another participation agreement at the distribution and state stage. However, do they agree not to sue even after if they advise at a state planning stage?
No, so they're two very separate stages there. So when we have the estate planning stage there, so we're all signing the participation agreement, but it's not so much about the not to sue, it's to deal with the confidential information that is being exchanged here. And very much when you're dealing with a collaborative practice matter in estate planning, we always at the start of it have to say that, look, we are involving you. This is family inclusive estate planning. Here's the participation agreement. But we are getting your input here as to what you wish to be in this will. At the end of the day, our clients are doing the will as to what they want. Whether the will we actually draft is what we have all taken your opinion on and had the family included on, it might actually be very different. So then if so the will maker actually then passes away and the children then realise, well, look, I thought in that, when we're involved in that, we gave our feedback to, mum and dad that we wanted this, this and this didn't eventuate. That would then start the second stage and you'd be doing an estate dispute and that would be they're two different participation agreements. Yeah. Absolutely. Yep. So the financial neutral and the coach sign it as well.
Are you aware of any situations where someone has sued despite the participation and the participation?
Not yet. I'm not aware of any situations yet. I'm not. Well, that's where the participation agreement is so crucial. And when I participated in my training, we actually had Stafford Shepherd from Queensland Law Society. He came and he spoke to us and he said that to operate as a collaborative lawyer, you must, particularly in that contested estates realm, you must do two things. You must advise your clients as to the other options. You must advise them as to litigation and as to mediation and negotiation. You must advise them as to all options and you must get that participation agreement signed. He was adamant that lawyers who are practicing in collaborative law without having a participation agreement signed are practicing dangerously. Yes.
With the financial neutral, are they disqualified from providing financial advice to that client down the track? So they're planning something else with their business.
No, now the agreements with the financial neutrals and the client, those are particular agreements that keep having to be modified as far as I'm aware each year because of their governing body and the requirements there, because really they're providing financial advice to sort of multiple clients in the one meeting there. So their particular agreements there with them cover that relationship there. I'm actually not sure if they're then disqualified because they're engaged. It's not then they're engaged for the process. So they're engaging and signing the participation agreement and the agreement with the client for that particular task process. It's not an ongoing retainer. So I'm personally not aware of that disqualifying them from acting for either sort of moving then forward.
Now I have Anton first. Anton, if you wanted to ask your question.
Thank you very much. Thank you, Kiri. That was really interesting. I very much enjoyed it. I've just got a couple of things I've got one comment and then two questions. The comment is, as far as training goes, I would consider I've taken a collaborative approach as a solicitor for over 20 years, but I haven't done a formal training course in collaborative law. So I just think a lot of lawyers learn their skills through, I've attended seminars and workshops and done training in that way, but not a full-on course. I think the best place to learn this is through practice. And I think I wouldn't be so quick on excluding lawyers on the basis they haven't done a particular training course. So you probably didn't mean that anyway, but I had a look at the website, the courses that you mentioned, and they look great. I think, if you can drag other lawyers along to this, if they agree to cooperate with the collaborative agreement, I think you can actually do great good by including lawyers who don't have the formal training to actually, engage them in it so they can become more collaborative lawyers. But yeah, so that's just a comment on training. A couple of things. Firstly, cost. Now, you may have dealt with this. I didn't hear the entire hour of your presentation. It looks expensive because you've got the lawyer for each party, and then you've got the communications expert, then you've got the financial expert. That's one factor. I'm wondering how you control that. That would probably scare people away because, we know as solicitors that cost is very much in the front of mind of many people when they're engaging in a legal settlement. Now, in estates, I guess the people engaging in the settlement aren't paying the bill, so maybe that has an effect on the willingness to engage. However, I think it is a factor, so I'm wondering how you deal with that. The other thing is, what about self-represented litigants? What about somebody who doesn't want to engage a lawyer? Can they be part of a collaborative process?
Okay, thank you for those comments there. Absolutely, just with your comment about, I agree. I think all the skills I've learned during my 11 years of practice, and absolutely that on-the-job practical training is just invaluable. I guess in our training, the advice we were given based from QLS and from Lexon was that the participation agreement to practice collaborative law, for the participation agreement, we need the lawyers to be collaboratively trained. Yeah, so that was the advice that were giving us.
Okay, can I just sorry to interrupt? How do you define a lawyer as being collaboratively trained?
Yep, so you can do a collaborative course, and then you get accredited as a collaborative law practitioner.
Who by?
The Australian Association of Collaborative Practitioners.
Okay.
Yeah, so the course has to be run by an accredited trainer, and the Australian Law Council has released guidelines. So the course has to be run by an accredited trainer, and the lawyer has to participate in a certain amount of training there before they can be accredited as a collaborative practitioner. And then you're able to sign the participation agreement as a collaborative lawyer. And QLS and Lexon have said that's what they're needing to see. But I have no doubt, as you've said, a lot of the skills that are taught in the collaborative training, lawyers may have just very naturally bring into that sort of lawyer-led process. I absolutely agree. Now, so I think your second comment there was about the cost. And yes, you are absolutely right. This is not a cheap option. This is not a cheap option and should never be sold to clients as a cheap option. What we can very confidently say is that it will very likely be a cheaper option than litigation. But it is not going to be as cheap as a very, very simple lawyer-led negotiation or the parties sorting it out themselves there. This, like I said, this is multiple stages, this is multiple parties. This is not a cheap option and should not be sold as such to clients. Still much better than some litigation matters that I've seen. Now, remind me again your third comment there about self-represented litigants. Without a collaborative lawyer, they wouldn't be entitled to sign that participation agreement. So, for example, if I was there wanting to do a collaborative matter and one of the clients was self-represented, I would not be participating until that client had a collaborative lawyer. I wouldn't be able to sign that participation agreement unless every client was represented by a collaboratively trained lawyer.
Okay, thank you for that. I've got to say, I've never heard of a process where a lawyer has been excluded because they didn't have some sort of training, and I'll have to do some research on QLS and Lexon because I certainly haven't seen any requirements from them that, particularly from Lexon, that require collaborative law training to involve in any process, but I'll take it on board and I'll check it. Okay, thank you.
Go ahead, thank you.
Thank you. And we had Michael Smith had asked a question. Does CDR agreement oust jurisdiction of court to decide dispute? You seem to suggest it does not. Your example of client refusing to participate.
Yeah, so the participation agreement, it outs the court for that is interdisciplinary team. So that particular matter, once we sign the participation agreement, if one of those clients then decides, no, I'm taking this to court and storms out, yes, they can still take it to court, but the entire rest of the team who signed that participation agreement, none of the lawyers can be involved in it. Right? So pretty much everyone needs to start again from scratch everyone needs to start again with a new legal team and go through the litigation path that way, which is definitely not cost effective. Right? So that's where, again, at the very outset, we are making clients so aware of this. It's fruitless if you're committing to this collaborative law process now, you should be committing to stay out of court. Right? This is what your agreement that you are signing is saying. And if it does turn out at the end of the day that one person does pull the plug and ends up taking it to court, everyone has to start again with a new team. So that's why getting the suitability of the clients at the very start is so important. And if you have an inkling that this process is not suitable for them and they want to go to court, then they're not suitable for that collaborative practice from the start.
And then I had Pauline Collins had said, congratulations, Kiri. Wonderful to see you further in Sydney and Toowoomba. We've taught it in our law degree since 2010.
Nice. Thank you, Pauline.
So we are right on or just over our hour. No further questions online or one more?
So there's an asymmetric house of courts. It asks jurisdiction of the court to begin, but not for the clients.
Yeah, so the clients are, so in the participation agreement, the clients are agreeing that if they threaten litigation, this agreement terminates and the collaborative process is at an end, and every lawyer involved in that is not allowed to be involved in the litigation, which is actually something that really, I hate to say, may be preventing some firms from taking it on, because they're very aware that, look, if we take this matter on and if it doesn't actually fails, we need to say goodbye to that client who may have been a client of the firm for a very long time, and we need to let another firm take on that litigation.
And then Michael had just had a follow-up question. Can the court take account of pulling out of an agreed participation process in exercising court's discretion?
Yes, court can consider, I guess, what they like with their cost discretion. I have no doubt that would be a relevant factor. One thing that is actually quite interesting, and to keep in mind as well, is that if that worst case scenario does happen and a client pulls out and it does go to court, everything that was disclosed in that collaborative law practice cannot be brought up at court. So we have to start back from the beginning. So if people they disclosed information in the collaborative law process, that can't then be used against them in the court process. Now, yes, it's going to be at the back of the client's mind, but the lawyers aren't involved and they have to start right back at the again with the process with showing the evidence there of matters. And what was discussed there in collaborative cannot just be brought up again here unless a client offers that information involuntarily. Does that make sense? Yeah.
All right. Thank you very much, everybody online. We had yes. Anton just commented, I doubt it. It certainly isn't provided for in the rules. There may be legitimate reasons for a particular party to pull out, except in family law. And if it is part of a dispute resolution process conducted by a family dispute resolution practitioner.
Great. Thanks for that, Anton.
So thank you very much, Kiri. It's been an excellent and very engaging presentation and very practical, which I love. We have a very small token but relevant token appreciation.
Joy, that is perfect. Thank you. I'll use that as I walk to the car.
Yeah.
Thank you, Kirsty. Thank you for having me.
Thank you, everybody.
Thanks all.